Good afternoon, everyone. Before I officially call our hearing, let me just check in with my court reporter. Harriet, are you ready?
I'm ready.
You can hear me okay?
I can hear you. Thanks.
Okay, great. Now calling proceeding number 24M-0274R. It's December 17th, 2024 at approximately 3 o'clock p.m. This proceeding concerns the development of template construction and maintenance agreements and preliminary engineering agreements for use in public crossing projects consistent with Rule 7214 of the Commission's rules regulating railroads, rail fixed guideways, transportation by rail, and rail crossings found at 4 CCR 723-7. This hearing was scheduled by decision number R24-0469-I, which was issued on September 11th, 2024. My name is Melody Mirbaba, and I am the administrative law judge who is assigned to hear this case. I'll just remind everybody that we've got a court reporter taking down everything that's being said. We are webcasting this hearing. That includes both the video and the audio. If we take any recesses, the webcast will continue, so please do keep that in mind. We are also recording this hearing. To ensure that we can have a clear record, I'm going to ask folks to keep your microphones muted until it's your turn to speak. I sort of see this case as a little bit more like a public comment hearing. However, I have encouraged pretty active participation from those of you who have decided to participate in this. So for that reason, what I would like to do is just get a sense of who we have here today. And I want to get entries of appearance from everybody who is here. Seems the best way I can do that is just I will call on the names that I see on the screens, and I apologize in advance if I butcher anybody's names. Please do correct me. I have a difficult name, so I understand what that's like. And also, if I refer to you by an incorrect gender, please do also correct me on that. I don't mean any offense. All right, let me start with the person identified on my screen as Caitlin Werner.
Good morning, Your Honor, or good afternoon, Your Honor. Caitlin Werner at QPWB here as outside counsel for BNSF. And I can let you know, I see that Shanna Cargill, who's in-house counsel for BNSF, is also present.
If you could spell your name for us so that we get it accurate in our record.
Yes, Caitlin, K-A-T-E-L-Y-N, and Werner is W-E-R-N-E-R.
Okay, and then the second name that you identified, if you could spell, or maybe this person, is it Shanna Cargill?
It's Shanna Cargill,
Okay.
Shanna-Cargill.
Wonderful, thank you both.
Thank you.
Okay, now I'd like to call on Brandon Dittman.
Thank you, Your Honor. Brandon Dittman of Wilson, Williams, Spellman, Dittman, representing the cities of Aurora, Arvada, and the Colorado Communications and Utility Alliance.
Thank you. I'd like to call on the person identified on the screen as M. Bedell.
Yes, hi, this is Michael Bedell, and I am a senior engineer at Weld County Public Works Department.
How do you spell your name?
Michael, and then Bedell.
Thank you. Okay, so let me call next on the person identified as Richard Corner.
Hi, Your Honor. Can you hear me okay?
Yes, we can hear you now.
Okay, hi. Thank you. Sorry, I was having technical difficulties there. Richard Kerner, that's spelled R-I-C-H-A-R-D, Kerner, K-O-E-R-N-E-R. And I work for Olson and represent Union Pacific as the public projects manager in Colorado.
Is Olson an outside engineering group?
Um, yes, a consultant.
Consulting, okay. Thank you. Okay, I'd like to call on the person identified as David LaPlante.
Good afternoon, Your Honor. David LaPlante, Director of Union Pacific Real Estate. Thank you, Your Honor.
Thank you. Now I'll call on the person identified as Jeray Swanson.
Hi, yes, good afternoon, Your Honor. My name is Jerrae Swanson, Jerrae, last name Swanson. I represent the city of Greeley and with the city attorney's office.
Thank you. Let me call on Amber Stoffels.
Hi, Your Honor. Amber Stoffels with Union Pacific, Manager Public Projects. My name is spelled Amber, Amber, Stoffels, Stoffels. Thank you.
Thank you. I'll call next on the person on the screen who is shown as Colby Rinker.
Good afternoon, Your Honor. Colby Rinker, in-house counsel at Union Pacific Railroad.
Okay, and then next I want to call on Sean Lanka.
Good afternoon. Yeah, Sean Lanka, paralegal, Union Pacific Law Department, SHAWNLANKA.
Thank you. Now I'd like to call on Heather Jarvis.
Good afternoon, Your Honor. My name is Heather Jarvis, HeatherJarvis, and I represent the city of Fort Collins.
Thank you. And let me call on Josephine Jordan.
Hi, good afternoon, Your Honor. My name is Josephine Jordan, counsel for Union Pacific Railroad. JOSEPHINE Thank you.
Okay, now let me just make sure I got everyone. If I missed anybody, please turn your camera on. Use the raise a hand feature. I think I got everyone. Okay, I'll just note that nobody has indicated that I have missed anyone. So the purpose of this hearing is just to hear from the participants on the results of their informal workshop, which was something that we discussed during the last hearing that we had. And then depending on how things have gone there, then to determine what the next steps are to getting template agreements that the commission can approve for use per Rule 7214. Is there anybody that would like to take the lead on updating me on how things went and where you think maybe things should go next? Mr. Dittman, I see you're unmuted.
I don't think anyone else is going to step up to the plate, so I guess that means I'm going to have to do it. So, yes, Your Honor, we met yesterday at the offices of Kutak Rock. Representing the cities in person was myself, and then we had numerous individuals from the railroad in person, railroads, I should say. There was the Short Line Association as well as Union Pacific and BNSF present at that meeting. We did have a number of municipal representatives and county representatives joining us via Zoom. And that was who was there at the workshop we had. Most of our discussion revolved around the issues that I know Your Honor is familiar with from this long proceeding of appropriations and indemnification, which are the primary, but by no means the only issues that we encounter in negotiating these agreements. And at least from our position and what we presented on that is that both BNSF and UP have already agreed to these provisions, either with CDOT or in some limited cases with individual jurisdictions, and that we would like to see that language in individual agreements. Now, I don't want to speak entirely for the railroads, but my understanding from them, and they can correct me if I'm wrong, is that they have concerns regardless of whether they've agreed to this in other places. They want to evaluate additional remedies they think are necessitated because of these requirements, and that they don't believe that uniform templates can be arrived at, and that rather maybe, and only a big maybe, some uniform language can be addended to various agreements or various type of crossing types. At the conclusion of that meeting yesterday, or close to the conclusion of that meeting yesterday, it was clear we are not really getting anywhere on consensus with regard to appropriations or identification issues. And so Union Pacific offered to send to me, and then for me to send to everyone else, some Word document templates of theirs that we would be able to redline to at least do some issue spotting as to what our issues are. And so we that was close to the end of the meeting. We did go through a few other issues that were identified in the comments, but I think holistically that was everything that was discussed. I mean, there are some additional issues that I learned of today that I'd like to discuss with Your Honor, but I think before we do that, the railroad should be able to give their perspective.
Okay, thank you. Does anybody want to speak up on behalf of any of the other participants?
Yes, this is Shanna Cargill, in-house BNSF, and I apologize. I'm not on camera. I'm having to drive. There were some flight delays last night out of Colorado, so I apologize for not being on camera. I do concur with the majority of what Mr. Dittmeyer said. I will note that the roads actually, traveled there to show up in person to really try to work out some of these issues. I do think a couple of caveats. Each railroad approaches things differently, and I would not presume to speak on behalf of UP or the other short lines, but insofar as BNSF's position with regards to the appropriation language, I think that is something we're willing to do. Mr. Dittmeyer did kind of hit the nail on the head that given that, because it's kind of a change from the appropriations, we would like to look at some of the remedy sections in these forms. Also, as to the indemnification, as so far as BNSF and Mr. Dittmeyer can clean me up if they have like a different take on this. Our language that we have, we feel like accounts for any limitations that a city may have to indemnify us. It states to the fullest extent by law. So as Mr. Dittmeyer pointed out, I think what we're going to try to do is, I think UP sent something over today. I think we asked the cities to provide the language that they would like to see. And then based on that, we would review based on the conversation that we had and the context that we had to see how we could kind of work within that proposed language. And like I said, maybe modify different provisions of the agreement to make sure it's incorporated.
Okay. That's helpful. Is there anybody else on behalf of maybe the railroads or any of the local governments that would like to chime in?
Caitlin Warner, I do second what Ms. Cargill just said. I think we addressed some of the discrepancies between the CDOT master agreement and how that's different than projects, which does warrant additional remedies. And then it's my understanding that as it relates to the provisions versus templates, we agreed we were going to hit the big provisions as it relates to where we potentially disagree, try to see if we come to that agreement. And that was what we had discussed as our starting point to try to get the ball rolling. And it looks like Mr. Dittman has some disagreement.
Yeah, I mean, I don't want to get into this now, but I would vehemently disagree with what has been represented today, that we only would redline these agreements with regards to indemnification and appropriations. I mean, we don't even know what these agreements looked like at that time. We just highlight those as the bigger issues. And in fact, we did go through other issues. And so to say that we're only discussing those issues, I feel is a misrepresentation of what we agreed to. We agreed to redline those agreements, and I can't forego the ability to see other issues if they exist. I mean,
and I would like to chime in. Those were the issues that were brought to us, the railroads. I mean, my flight wasn't until 5 o'clock. I think we discussed those, I think we came to an agreement with Mr. Dittmeyer that that would be the place that we would start. If any
I disagree
representation,
highly that that's what I.
if there was any representation that we wouldn't look at other provisions, that was fine. But during that conference, those are the things y'all wanted to talk about. If there were other sections you were willing to talk about, I hope we didn't give the impression that we weren't willing to talk about those. We all agreed, when the meeting should end. But again, I in no means mean to imply that we are limiting to you guys. I'm just updating the judge to let you know that that was the majority of the issues based on the comments that were submitted by the city that we ran through, was dealing with the appropriations and the indemnification. I would also like to note for the judge, there was some discussion about fees that the cities have. And because of antitrust and anti-collusion, we can't talk about our fees with other railroads present. And we did offer the cities, if they have any questions, especially with BNSF fees or any kind of fees, to reach out to that railroad individually, and we can kind of walk through those and have those as an offline discussion. But that was really the only topic we said we're not really comfortable discussing as a group because of the antitrust issues and implications regarding rates and how things are calculated. But we did offer the cities to reach out to us directly. We'd be more than happy to have an offline conversation about those particular questions.
Mr. Dittman, you seem to be eager to chime in again. Maybe I'll give Ms. Jarvis an opportunity since she has unmuted herself. Ms. Jarvis, did you or your client participate in this meeting yesterday?
Well, we were there in person via Brandon, Mr. Dittman, and we were also there via Zoom. And the two largest topics that Mr. Dittman has raised are where there was quite an impasse. And so the next step seemed like we needed to really focus on the larger items, but I wanted to support and reaffirm what Mr. Dittman was saying, which is that we didn't say those were the only matters, just the largest items we kept running into an impasse with trying to get anywhere. So it seemed like the better route would be to take the agreements, and I believe the railroads were going to be providing them to Mr. Dittman, and then he was distributing them out from there, so that we could try to get to a better place with these large elements, that both the appropriation and then the indemnification, and then from thereafter address some of the smaller, lower hanging fruit. I guess, maybe that's in reverse. I guess people usually you're supposed to do the low hanging fruit first and then the harder parts, but we were jumping right into the harder parts, which is why we moved to a different method, because at the meeting, at the in-person meeting, there was just such an impasse at where to go from there.
If I could clarify the end of what I was stating, I was saying that that's where we're starting. I've never said we were precluded from other things. I did say we ended the meeting early, or Shanna did, but again, I apologize if that was misconstrued. I didn't say those were the only things that were addressed, but that's where we decided we would start because they seem to be the biggest issues.
Okay, and Mr. Dittman?
Yeah, and all I'd say to that is I received 2 emails today saying that those are the only 2 issues at which we could redline the agreements that were sent to us. And so I agree we should address those biggest issues, but by no means can I agree, would it be reasonable for any person to agree that to limit their ability to review a contract to only 2 issues. So that's why I came into here somewhat upset, kind of given where we left yesterday and feeling good about the way forward versus what has been represented to us today.
Well, and I would just like to add the reason why that may have been misconstrued. What I said was I was not on these emails, so I'm not familiar at all what you're discussing.
Okay, Mr.
Your Honor, Your Honor, hi, David LaPlante from Union Pacific. I sent the emails, and I spoke for Union Pacific yesterday's meeting in Denver, and the primary reason that Union Pacific was concerned about limiting the review to our 2 standard form agreements to those 2 issues was really more of a practical matter. These projects are very unique and specific. Union Pacific, in an attempt to resolve the issue, provided those standard forms today. One was an at-grade road crossing agreement. One was for a grade separated road crossing agreement. And just the time and resources to, if we had, 30 cities reviewing 100 provisions, I would suspect it might take us a very long time to respond. And based on how the meeting went yesterday, I thought it ended well, and these 2 issues were very critically important to the cities, and so I thought it was best to try to resolve these 2 issues. We did have more time, and there weren't other large issues brought up that would have, at least from my review, required significant edits. And so, as a practical matter, that is why we wanted to limit it to those 2 issues. Thank you, Your Honor.
Okay, and we've had a lot of back and forth, so I think maybe I just need to kind of step in and just clarify what the goal is here so that we can all get on the same page. And I know I recognize many of you from the rulemaking hearing that resulted in Rule 7214. That was my rulemaking case. And so I'm quite familiar with what we're trying to accomplish here and why we're trying to accomplish here. I think what Mr. LaPlante just said is indicative of the things that we're trying to deal with for the future. So this right here in this process is the time to take on the issues and to deal with them and to address them. And if it takes more time to get it done, then that's what we're going to do, because in the long run, it's going to save everybody. And that's not just for the local jurisdictions. That's also for the railroads that are having to put a lot of time and effort every time there's a new contract to look at all of these terms over and over again. We're trying to save everybody's resources, but that means we're going to have to put some resources into it up front. And I don't want to be in a position where I am dictating what your contract terms should be. I really want all of you to be heavy-handedly involved in that. I really want these to be agreements. I think one of the major baselines that I know I'm going to be looking for is that we are going to have contract terms that don't violate Colorado law. There just should be no argument about that. The issue of appropriations is one of those issues. So there shouldn't really be much of a debate about that. I understand that there may be questions about maybe other contract language to provide some protection, because I understand what that might be like on the contracting side, due to that limit. But that's the limit of the law. Those laws have been in place for a very, very long time, and they should have been followed all along. We shouldn't even have to do this, but we're going to, and it's going to get done. And I think we just need to take the time, whatever time it takes, to get this done. And I know that these contracts were already supposed to be in place and they were already supposed to be used, but they're not. And it's going to happen when it happens. And I'm not looking to drag this out for years, but I am looking to get this done right. And I am looking for everybody to really come to the table knowing we will end this case with agreements that will have to be used. That is going to happen. So I just want everybody to keep that in mind. And also keep in mind one of the biggest things is that we have to have contracts that don't violate Colorado law. That's pretty simple from my perspective. And I get each project is going to be different. I don't think the commission is either. We're not looking for these agreements to get into a lot of the specifics for each individual projects, because each one of those is going to be different. We're looking at the language that can transfer and translate into contracts across multiple public projects, or really all the kinds of public projects over which the commission has jurisdiction.
And Your Honor, this is Shanna Cargill, and I would like to clarify. I kind of thought that, at least at the meeting, and maybe people have different perspectives, I thought that's kind of what we were trying to do. And I'm not trying to just talk about these 2 clauses, is saying, and again, I'm not going to speak for other roads, but our indemnification and any anti-appropriation language, those do appear in a lot of our contracts, so they can, be used, because again, as your point, each project is a little bit different, right? And I know we're not going to get into like each detail of a project, but that's kind of why we thought starting with, we opened up the floor. What do y'all want to talk about? These are kind of these big high level things. And that's why we wanted to kind of work on language first, because they would be implemented once we reach an agreement into the various templates going forward, if that makes sense. But again, I guess I would like to reiterate, I mean, BN never meant to say these were the only issues. These were just the two that it seems like the city wanted to really kind of talk about. And like I said, at least from BN standpoint, we've already had that language. We'd like to look at some of the maybe additional language around it. But that was kind of what you said, Your Honor. What I thought we were trying to do is let's work on these clauses that appear across the board in any agreement, right? And come to an agreement on those and then move on from there.
It's certainly, I don't really have an opinion on which issues should be tackled first in all of these discussions. I do agree those are probably big ones, and they in some ways ought to be low-hanging fruit. Apparently they're not. I'm also wondering, did you all agree to anything? Was there anything fruitful or productive that came out of this that, okay, we agree, Colorado law says this when it comes to appropriations, and we can't contract in a way that violates? I mean, do we at least agree on that?
Yes, Your Honor, I think that's fair. And and again, I'm not going to speak for the railroads, because I think there is, each railroads do things uniquely, right? Even though we're in the same business. So I'm definitely not speaking for UP or the short line there. So this is definitely for BNSF. I think our provision is, and we have done this in the past, we are willing language in there, but we did tell the cities we're going to kind of have to look at the remedies in case y'all don't make the appropriations. What other things we can do to make sure for safety and all that stuff that the infrastructure is being maintained. And so I can at least say from BNSF standpoint, I feel like we have all of that. I also, again, unless someone has a different opinion, I mean, our language and our templates say to the fullest extent, and we just ask them, what other saying
Ms. Cargill, you keep cutting out.
We can't do this on indemnification or different things, like what kind of language they want in there. So again, oh,
you're cutting out.
I apologize. I'm so sorry.
Yeah.
I'm in a low area.
Also,
can you hear me now? Is this better?
Yeah, and I need you to slow down. You're talking really fast, and I'm concerned that our court reporter will have a hard time capturing all of that.
Oh, I'm so sorry.
And I've heard what you all are saying. It does sound like maybe there might have been some misunderstanding. And I don't know, and you know what? I'm not judging. I'm not putting blame on anybody. Like this is the first conversation you are having about all of this, and it just happened yesterday. I think we're really, really early on in this process. And while those two issues are big ones, they certainly can't be, they're not everything. Mr. Dittman, you were raising your hand. I didn't know if you wanted to add anything.
Yeah, I mean, the only thing I respond to is I don't think these issues are resolved in terms of appropriations and indemnification. I think, Ms. Cargill maybe seem like we have resolved that issue. What I will say is that, especially with regards to appropriations, is not standardly in any templates. A few places have been able to get some appropriations language into their contracts. But I mean, first, during our discussion yesterday, it was denied that these appropriations clauses were in any agreement. So we had to walk through, the CDOT agreements, which have appropriations language. Fort Collins happens to have a CNM, which has appropriations language, but by no means is that standard. And in most places, it's not agreed to. And so I just want to push back a little bit, like, oh, we all agreed on this, because it certainly was not agreed upon for a long time. And, I'm happy to look at whatever changes are proposed with regard to remedies. I don't know what those are yet. But, we came into that, saying, let's work off the CDOT language, because obviously that has been agreed to. And that was obviously off the table pretty quickly. So
I'm not really getting that impression that things are off the table, but maybe I'm misunderstanding. Ms. Warner, I see you've raised your hand.
Yeah, and I just want to provide a little clarity. I know there was a reason why the PUC wasn't involved in those, and so I don't know if we really, if you much care to rehash it. What we did come up with, so that, because I don't think this has been addressed with you, is that we did come up with how we're going to address it. I believe Mr. Dittman was going to put together his first draft. We were going to look at that, then we were going to draft remedies. So why we don't have the exact language, we came up with a plan in which we were going to address those. So I think that's helpful for what maybe the PUC is interested in at this time on whether we are working to, you know, put pen to paper and see where the parties agree with that language and then having appropriate remedies.
Okay. Does anybody else want to comment on the meeting that you all had yesterday? Mr. Dittman, you were raising your hand. I don't know if that was the reason you raised your hand.
I have a question for the ALJ about what the end result of this should look like, but I think if anyone else has comments on the meeting, you know, they should go first.
The end result of this entire proceeding is going to be template agreements that ultimately, you know, whether it is by allowing my recommended decision to go into effect to become a final decision, or, you know, the commission deciding on exceptions, whether to approve template agreements. So my goal is to actually have the template agreements that I can then write a recommended decision and say, these should be approved, and these should be the ones that are being used consistent with Rule 7214. And if your question is, what should those template agreements look like? The main guidance I'm going to give you is that it has to be, we can't conflict with Colorado law. And I mean, that was something that came out in the rulemaking that was pretty, I found disturbing. And I think we can end that. We can fix that if we all work together. And I know that, you know, I remember from the rulemaking hearing that there were some comments that, you know, when it comes to these kinds of projects, you know, the railroads it doesn't really benefit the railroads. And so that might maybe that impacts how the railroads view these contracts. And I can understand that. But we're in the position, we're in the place that we are, and we just have to, you know, put our heads down and move forward. So what I really like to hear is what folks think our next steps should be. Mr. Dittman?
I have one clarifying question
Sure.
to your honors about, I understand the end goal is to create template agreements. Is the end goal to create universal template agreements that would be used by all railroads? You know, understanding that projects are different and that they're going to be different agreements for different types of projects, but is that the goal, or is there going to be, you know, 3 or more sets of template agreements for each railroad?
I think there might be some flexibility in the rule on that. But I would prefer there to be fewer of them, because I think that simplifies things. I don't know how realistic that really is. Most of, you know, the kinds of public project cases, you know, that I see are contested cases involving Union Pacific and BNSF. And so those seem to be the big ones that at least the commission gets involved with. That doesn't mean that, you know, the smaller railroads, the short lines, don't also have cases, and that local governments don't also enter into contracts with them. So I don't know how drastically different it would be for the other railroads. Ideally, I would like the majors, BNSF and UP, we would have templates that both could use, rather than having 2 different ones, because railroads like to say they do things differently. I've heard that a million times, by the way. I know the railroads have their own processes and do things their own way. I get that. And if we have to have unique ones, one for BNSF and one for UP, okay, but I would really rather it just be one for each, because I think we should all be able to get on the same page on these issues. Does that make sense?
Yes, Your Honor. And this is Shanna Cargill. I have a really quick question regarding like the templates. I know we said we're not, you know, each project can be different, but I guess one, just, and this may be a dumb question, but for example, if we work out a template agreement based on insurance requirements, right? And so let's say we present a template and it says insurance is 2040, but 3 or 4 years, 5 years from now, the insurance changes and, you know, things do go up over time. Would we have to go back to the PUC to update insurance requirements based on underwriting? I guess I'm just trying to make sure, you know, when we're saying a template, for certain provisions, would there be flexibility just based on the passage of time, or maybe different laws that come down either on the railroad or the city's side? How would we have to go through a PUC template update for each change like that?
Possibly.
Okay.
But what I can say right now is that this is a kind of a thing that I need to be able to identify now as we're crafting these agreements, so that I can figure out what I want to recommend to the commission, whether we should have to come back for those sorts of things, or whether parties to these agreements should have the flexibility to work on those issues among themselves. So I'm looking at fixed things versus flexible things, and I'm counting on the parties to tell me what you think needs to be fixed and what you think needs to be flexible.
Okay, and that's fair enough. And like I said, we'll just make sure we'll denote that with any type of template that we present to you, Your Honor.
That's helpful. Okay, does anybody have any thoughts on next steps? I mean, from what I've heard, as of now, there is a BNSF template that's being shared or will be shared with Mr. Dittman in Word, so that you can add red lines to it. Is that correct?
Yes, Your Honor.
Your Honor, this is David LaPlante. It was actually Union Pacific. We sent the two templates, one for the at-grade road crossing agreements and one for grade separate road crossing agreements earlier today. And we did share those again just a couple hours ago. And just to clarify for your Honor's information, there are other types of projects that would require different agreements, and UP is very willing to and able to work to make sure those other agreements are also reviewed. We just thought we would start with the two most commonly used forms from UP's perspective. I don't want to speak for the BNSF, but it's probably the same for them, in that there's a significant number of at-grade road crossing projects and grade separated road crossing projects.
Do we think that the UP and BNSF can get on the same page in terms of these agreements? Because I'm a little concerned that we're going to have UP red lines, and then BNSF will have their own template that then they want to redline, and we can't. Never the twain shall meet. And I would like them to meet. I would like to not have a lot of competing agreements that we have to debate every single term over.
No, we discussed that in the meeting. So UP sent that over to us, and we said once we got it, we would kind of wait for the city's responses, and then we would kind of or we could do it beforehand, layer our comments in as well, or our revisions. But that was our goal, was to have, at least on those provisions, I think UP and BNSF can work together and have very similar provisions. I mean, I don't think we're necessarily married to our form versus UP form. I mean, there's just certain risk mitigation that I do think the railroads are aligned on that we would be looking at.
Okay, I do want to throw it out there to all of you for any suggestions on next steps.
Your Honor, may I at this point kind of, so I just want to add to what has occurred today, which is that yes, we did receive two agreements from the UP. I did send those to all local government council that were on the notification, notice of participation list. So that has been sent out. But I just want to clarify with Your Honor that in redlining and reviewing these agreements, we are not just limited to appropriations and identification, because those were the instructions that were sent to us.
I think that's clarified.
This is David LaPlante from UP, Your Honor. Yes, you made that point very clear. And so, Brandon, yes, that issue was discussed and clarified. And again, Brandon, I was really trying to keep us focused. I was not trying to limit forever any comments on our forms. I just know how much time it takes both our respective parties to get stuff done. But Your Honor made it clear that she wants us to focus on other issues. So UP is on board with that.
It's more about being efficient. If you're looking at a contract, look at the contract. I mean, you don't have to just focus on two things. I get that those are really big issues and are going to require quite a bit of attention, but I by no means intend for this to be limited to just two issues. So, okay. So again, anybody have any thoughts on what the next steps should be? For example, do you think it would be helpful after you've had a chance to Mr. Dittman and all the other local governments have had an opportunity to look at Union Pacific's agreement and provide red lines, discuss among themselves, send back to UP and BNSF, and then BNSF and UP have an opportunity to look at all of that? Do you think that meeting after that could be helpful? Is that something that you think maybe ought to be a good next step?
Yes, Your Honor, and that's something we've already discussed at that meeting, that would be the next step, that once we had an opportunity to get their red lines back, we would get with UP as well. Again, there are certain things I want to make sure because of the antitrust that we can discuss. I think all of these things are open other than the fees that we can, have these conversations about. And then it was my understanding, I'm going blank on the timing, but we did say maybe in the next 2 or 3 months, get back together again for another meeting to address the comments and see where we can work on it. Brandon, is that correct? I'm kind of going blank on when we said we'd get back together.
That's correct. I mean, given the holidays coming up, we all recognize it's going to take a while for us to get together as the cities and the towns and the counties to review this and get our red line together, send back to them, and then of course the railroads to review. And I think we can try to do another meeting afterwards to discuss. I would like to suggest that we do schedule another status conference though, to kind of check in, with Your Honor, and if we are at an impasse, look for a different way forward.
Yeah, that's definitely on the table. I was planning to do that. I think it's helpful, and at some point, I may need to be more formally involved, or we might try to do something more resembling like a mediation between all of you. So we'll see. I think we just need to see how far you all can get working together. And I do think that a follow-up hearing date is a great idea. I'm going to look at the calendar right now. When I was thinking about a follow-up hearing date, I was thinking about March, but I really would prefer you guys have more than one day between when you meet and when we have our hearing. So maybe we should push that out, because what I would anticipate is that you guys might be able to meet by the end of March. Do you all think that that's reasonable, that you might be able to do this back and forth with the red lines and then have another workshop type session by the end of March? Okay. I'm going to
Your Honor, this is Dave LaPlante from UP, and I just wanted to make sure we also chimed in that we are absolutely willing to have that next meeting, and I think that date is doable from our perspective, Your Honor.
Okay. All right. And I'll just assume if you don't speak up, that's a reasonable, you all agree it's a reasonable timeline that you can have all those exchanges and have another meeting by the end of March. So considering that, I want to look at having a follow-up hearing in April. And again, I don't want it to be like the day after you meet. So what I'll do is set up March 31st deadline for you all to have your follow-up meeting. And I am looking at April, right, or the calendar in April. How does everybody look is everybody pretty open the week of April 14th?
Yeah,
Yes.
this is BNSF. We could make mid-April work. I do want one note. I'm going to be involved in a 2-week arbitration starting mid-March on another matter. So I don't know. We'll coordinate with of course, Brandon about getting the meeting together. But to your point, I do think there needs to be a little bit of time between when we confer and that status conference.
Yeah, I mean, what I was thinking is that I would set a March 31st deadline, but you all can definitely meet before that arbitration. You can meet before, you go into that.
Yeah.
And come up with a timeline that works. Okay. All right, let's go with tax day, April 15th. I'm going to do it at 1 o'clock. It will be fully remote. just like we've been doing. I think that makes things easier on everybody to appear from wherever you happen to be. And it does tend to save everybody time and money. Okay, so I will write up a decision highlighting at a high level what we talked about today. I'm not going to get into the, the nitty gritty back and forth that we had and appropriations versus indemnification. I'm not going to get into that level of detail in my decision, but I will describe what we discussed here today and what I'm anticipating to be the next steps on your end. And I will set a March 31st deadline for you all to have another meeting. And then we'll get back together on April 15th at 1:00 p.m.
Your Honor,
Yes.
is there any chance that you would consider 2 instead of 1 on the 15th? We just have a standing meeting on the Tuesdays.
Yeah, I actually, the whole day is open. So if anybody else
Thank
has
you.
any issue with 1:00, that's just speak up now. I can work around it.
Thank
2:00 is better for you?
Thanks.
Okay. Well, then we'll do it at 2:00 unless anybody else speaks up with any concerns with that time.
No, 2:00 works better for BNSF in our time zone as well. So I'd appreciate
Okay. Okay, and these notices and that Zoom information to join are being emailed to everybody. And so watch for that email. And I would also just encourage those of you, if you want to make sure your colleagues get the email, to check in with them. I know early on in the case, there were some questions about who was getting what. So I'm hoping that's all been cleared up. I did some digging to make sure we could avoid that in the future. So everything should be fine now, but it doesn't hurt if you want to share the Zoom information with others that have participated. We're not posting it on our website because I just try to limit the opportunity for non-participants to interfere and sort of Zoom bomb our hearings. So that's why they're sent via email in these kinds of cases. Okay, well, I appreciate everybody's efforts. I know that this is it's going to be a heavy lift for everyone, and it's going to be a lot of work, but I think we will get there eventually. And I really want to encourage everybody to try really hard to come up with something that you all can agree to, because I will tell you what you don't want is you don't want me writing your agreements. You really don't want that. I'm not a contract lawyer. It's going to take me a lot longer, and I do not necessarily know all of the level of detail that all of you are aware of that you deal with in these contracts and how contracts go sideways on these projects. That's not information I'm particularly privy to. And so it would be much better for everybody if you could all work out these agreements. All right, with that being said, I want to thank all of you for being here, and I will issue a written decision and see you all on April 15th at 2:00. Our hearing is adjourned.
Thank you, Your Honor.
Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.